Very warm welcome to all. Today, I, KHANNA, a legal intern under LEXIS and Company, am here to explain my topic, Conciliation and Settlement Agreement as forms of ADR. ADR meaning Alternate Dispute Resolution. India is a country enriched with abundant natural resources and an enviable demographic dividend waiting only in availability of capital to propel the country on a path of unbridled economic growth. To attract investment from around the globe, it is imperative to promote ease of doing business, of which the judicial mechanism on settlement of dispute plays a vital role. And to take care of that, arbitration has been introduced in the Indian legislative judicial system, although the provisions on the same have been around since 1940. It is in the recent years that commercial arbitration has received increased impetus to ensure that the disputes are resolved in a time bound manner, aimed at reaching a decision that pays heed to the economic and judicial interests of the parties involved. With the benefits apparent over the traditional court system, arbitration is steadily becoming the preferred system of dispute resolution. However, being a relatively nascent mechanism, training and research in this arena is underdeveloped. This particular video discusses the legal provisions that allow for undue judicial interference in the ADR mechanism with reference to relevant case laws where the same has been brought to attention. There are a few methods accessible for resolving dispute between two parties. They are mediation, conciliation, settlement agreement, and many others. The first and the most common method is resolving dispute through courts when a dispute arises two persons belonging to the same nation. Three medium of resolve the dispute is the same meaning. Thereby, the parties get resolved their dispute through the courts established by law of that country. This has been the most common and important methods followed by the citizens of India for resolution of their dispute with the fellow citizens. As Lord Bryce once said, there is no better test of excellence of a government than the efficiency of its judicial system. Let's talk about alternate dispute resolution. Alternate dispute resolution, as the name suggests, moves away from the traditional court system and hence is a better attempt to devise machinery capable of providing an alternative to the conventional methods of resolving disputes. ADR offers to resolve matters of litigants, whether in business causes or otherwise, who are not able to start any process of negotiation and reach any settlement. The ADR mechanism takes into account that the court-based dispute settlement mechanism is expensive and time-consuming, whereas this opens a need for the alternative mechanism that would make the process simpler and address these concerns. The use of ADR as a tool to reduce the backlog of cases in India through arbitration, mediation, and conciliation and settlement agreement. Lok Adalats, Gram Nyayalas, and Nyaya Panchayats are the contribution of India to the jurisprudence of ADR. This concept covers a number of methods of dispute resolution which fall into the two broad categories: court annexed options and community based dispute resolution mechanisms. If talking about court annexed ADR includes mediation and conciliation, where a neutral third party assists the disputants in reaching a mutually acceptable solution. The supporters argue that such methods decrease the cost and time of litigation, improving access to justice and reducing the court backlog, while at the same time preserving important social relationships for the disputants. Let's understand the meaning of conciliation. Conciliation is one of the non-binding procedures where an impartial third party known as the conciliator assists the party to dispute in reaching a mutually agreed settlement of the dispute. As per Halsbury laws of England, conciliation is a process of persuading parties to each an agreement. Because of its non-judicial character, conciliation is considered to be fundamentally different from that of litigation. Generally, the judges and the arbitrators decide the case in the form of a judgment or an award which is binding on the parties, while in the procedure of the conciliation, the conciliator, who is often a government official, gives its report in the form of recommendations which is made public. Now, let us understand what is the meaning of settlement agreement. A settlement between the disputing parties is a much needed resort in the modern day commercial world. A settlement ensures that the dispute between the parties end in amicably terms, leaving each party satisfied. In turn, outside court settlement procedures like conciliation ensure fewer burdens on the court and also lessen the cost of litigation for the parties in dispute. Thus, these settlements have been welcomed by litigants and courts alike. Therefore, the courts have not hesitated or disputed in giving finality to the terms of a settlement agreement like an arbitral award under the Arbitration and Conciliation Act of 1996. That is all for this particular video. In the next video, we shall be understanding how the judiciary has interpreted and included the mechanisms of ADR such as conciliation into the system. Thank you so much.